Hello, and welcome back to Business Law Online. This week we're going to be covering torts, a very important subject. And the lecture series, there'll be at least 2 lectures this week, but I'll try to keep them as brief and concise as possible. Tort law is important. It's important because when dealing with torts, what we're talking about is when are we going to make one party pay another party for the injuries that they've caused that other party. We're talking about compensation. Now, normally this is associated with personal injury law. So you'll see attorneys advertising on television, if you've been injured, call us for a free consultation. And that is definitely part of tort law, without a doubt. But tort law also includes damages to one's business. There are even actually contractual torts. It's possible to commit a tort before contract and during contract. So it's much broader than just personal injury. Now, tort law centers around 2 ideas. One, rights, and the other, duties. And these are found in the common law. They're not new ideas. People have certain rights, certain civil rights. For instance, you have a right not to be touched in a harmful or offensive manner. In addition, people have duties. Each one of us owes the other certain duties to behave in a certain way. And if we violate those duties, we may be liable for somebody's injuries. So rights and duties, very important concepts in tort law. Now, tort law, if you remember way back when, my first lecture, I talked about the differences between 1, criminal law and 2, civil law, specifically the purposes. And one of the purposes of tort law was to determine when to shift a monetary loss from one party to another. In other words, to determine when are we going to force one party to compensate another for the injuries they've sustained. Now, again, it centers around this idea of duties and rights. Just because you've been injured by someone doesn't mean that you can sue and prevail. You have to establish one or the other. Either they violated one of your rights or they violated a duty that they owed you. All right. And again, tort law is about compensation. And I want to start the conversation off with that because it's really important. Compensation, or another word for compensation, damages. And usually in tort law, it's about money. It's about making one party pay for another. Now, damages are an important concept. And it's important to keep them straight. Now, there are 2 types of damages. You have 1, compensatory damages, and 2, punitive damages. Now, compensatory damages are about making the party whole for the injuries they have actually sustained. So, for instance, if I were injured in a car accident and I couldn't work for 3 months, and I wasn't paid for 3 months, part of my damages would be 3 months' pay. But compensatory damages fall into 2 broad categories. 1, special damages. Now, these are quantifiable money losses. So, for instance, the example I gave before, lost wages. You could also say, lost vacation time, lost sick time. Those are benefits that you accrue, and they have value. They have value to you. So if you have to use those days, you can collect for those days. Medical expenses, another big special damage item. Physical therapy, hospital expenses. If it's a property damage claim, the cost to either fix or repair or replace the property that has been damaged. Again, special damages are quantifiable money losses. The other type of damages are general damages. Now, general damages are a little more amorphous. That's for things like pain and suffering, loss of reputation. In other words, things that have affected your quality of life. It's a little bit harder to put a quantifiable money figure on those things. The courts have, over the years, they have put quantifiable money losses on such things as pain and suffering and loss of reputation. So what you'd have to do is you have to take a snapshot. Your life before the accident, your life after the accident. Before the accident, you had an active life. You danced, you worked out, you went to school, you were involved with charities, you have a family. Now, how has the injury affected your life afterwards? Do you still work out? Are you still active? If so, how much? Are you still involved in your community? Things like that. So those are general damages. Now, the other type of damages, very important, are punitive damages. Now, punitive damages are reserved for the most extreme situations. Punitive damages, as the name suggests, is about punishing the individual. It's not about compensating. It's not about compensating the victim, the plaintiff. It's about punishing the defendant. So, for instance, suppose I was hit at a red light. I was, stopped at a red light, waiting for the light to turn green. All of a sudden, boom, I'm hit in the rear. My car is totaled, and I was thrown around the car, even though I have my seatbelt on, and I'm in a lot of pain. Maybe I have tremendous back pain. Maybe my head hit the windshield, something like that. Well, the person gets out, the driver of the other car gets out, and suppose they say, "Oh my God, I'm so sorry. I wasn't paying attention, or when I tried to stop, I couldn't. There was a puddle, and I just hit you." That's pretty routine negligence. Really, nothing bad about it. I could certainly sue that person because they have a duty to slow down and come to a complete stop under any traffic circumstances. There's a duty. We talked about that briefly. But what if that person comes out of the car and it's obvious they're inebriated? They've been drinking heavily. They're slurring their speech. They can hardly walk, hardly keep themselves up. Well, I could certainly sue them, but what else have they done? They've committed a crime. DWI, DUI. That's bad. In addition to compensatory damages, I can also sue for punitive damages. Why? Because what that driver did was so egregious that not only should they compensate me for my damages, they should be punished. Now, right off the bat of it, right off the face of it, punitive damages, they're almost criminal, right? They're really for things that could also be considered crimes. So if that's the case, then why should they be payable to the victim? Why should they be payable to the plaintiff? But nonetheless, they are. They are payable to the plaintiff. So in terms of damages, very important. There are two types. You've got to keep this straight. I'm going to expect you to know this. One, compensatory damages. That includes special and general damages. Two, punitive damages. And that's all about punishing the defendant. Now, damages is really a hot button issue in a lot of states. A lot of states have taken to capping damages. How much can you collect for a lawsuit and the like. And this debate usually centers around the infamous tort tax. So how does the tort tax work? Well, ask any doctor how it works. Doctors, medical malpractice actions, even a very modest medical malpractice action could be worth hundreds of thousands of dollars. That money has to come from somewhere. Now, it usually doesn't come from the doctor's personal accounts, personal monies. It's usually paid by insurance. So doctors carry liability insurance, just like any other business does. If you walk into a car dealership, they have liability insurance. If you walk into a factory, they have liability insurance. If someone is injured on their premises, the insurance is there to make sure if there are damages, if the insurer does owe damages, the insurance is there to make sure those damages are paid. Well, the insurance companies don't do that for free. They do that by charging a premium. Cars, for instance, I imagine most of you drive. Um, Maybe at this point, most of you are old enough that you have your own car insurance. Those who aren't, maybe still on your parents' car insurance. How does that work? Well, ideally, you pay your premium, and you don't get into any accidents, and that's it. Um, Now, the insurance companies obviously have to make money. They have to make money off the premium. So what they do is this is overgeneralizing it, but they basically compare payouts, how much money have they paid in damages, to premiums. Now, obviously, if they're paying a lot more in damages than they are collecting in premiums, they have to raise premiums. Hence, the infamous tort tax. What do you think about that? Is there validity to it? What are the pros and cons? I mean, on the one hand, people who are injured through no fault of their own because someone has violated one of their rights or violated a duty that they owed, well, they should pay. If I'm injured and I can't work, shouldn't that party, because of someone else, shouldn't that party pay for my damages? But on the other hand, it does make doing business expensive. Liability insurance is not cheap, especially for businesses. Why? Because businesses have a lot of contact with the public, a lot more opportunity for what? People to get injured, and they do. So the infamous tort tax. It's a hot button issue. It comes up from time to time. It's torts, as we learned, is mostly a state issue, so it's handled state by state. For instance, in California, for medical malpractice claims, they cap damages at $250,000. May seem like a lot of money, but not really. Not really. Other states have cap damages at $750,000. Again, it may seem like a lot of money, but if you're really that injured and needed lifetime care, and it really isn't that much money, believe me. Good care can cost easily $3,000, $4,000, $5,000 a month. So $700,000 would be eaten through pretty quickly. But anyway, what are the pros and think about what are the pros and cons of the tort reform, the tort tax argument. All right, there are two basic types of torts. One, you have intentional torts, and that is usually someone has violated one of your rights. Two, we have negligence torts. That is, someone has usually violated a duty they owed you. I'm going to focus on intentional torts first. Now, what is an intentional tort? Well, the tortfeasor, and if you sued them, they would be the defendant and you would be the plaintiff. The tortfeasor, one, intended to commit the act and intended the consequences, or at least the consequences were substantially certain. Now, intentional torts include torts to persons, torts to property, torts to businesses. So we're going to go through as much as we can. I don't want to keep this lecture longer than 40, 45, 50 minutes tops. The first tort, and the simplest tort, and they usually go hand in hand, assault and battery. They're important to know because oftentimes when one tort is committed, multiple torts are committed. So we're going to start first with assault. Now, assault is the threat of harm. So if you threaten someone in a way that is immediate, where the threat is immediate, the harm, it could be physically harmful, it could just be offensive, but if you threaten them with words or gestures and you're in their immediate area, you have caused the apprehension of a harmful contact. Now that contact, it can be harmful, like physically harmful, or it could also be just offensive, being touched in a way that you don't want to be touched. So that is battery. It's creating a physical, it's creating an apprehension, a reasonable apprehension that someone is about to be touched in either a harmful or offensive way. So if someone is really close to you, suppose, for instance, um, um, I'll use this as an example. Um, you can't stand your boyfriend anymore, and you want to hit him. You want to hit him with a bat. So you get real close up to him, and you take a bat, and you start shaking at him, and saying certain things to him, like I'm gonna, smash your face in. Well, that would cause a reasonable apprehension of a harmful or offensive contact. Now, what if you actually hit your boyfriend? Well, then that's the tort of battery. And battery is any unexcused, harmful, or offensive contact. So usually assault and battery go hand in hand. It's assault when the person sees it coming. It's battery when you actually make the contact. Now, why do I go over assault and battery? What does it have to do with businesses? Well, the next important tort is false imprisonment. Now, I'm sure that many of you have worked at retail establishments of one kind or another. And I'm sure that many of you have gotten instruction about what to do if you see someone shoplifting. Now, store policies vary, but it's not uncommon for a store to say what? Just let them go. Um, try and get a picture of them, try to distract them maybe so we can get a picture of them, or something like that. Now, some stores are more aggressive about going after shoplifters. Maybe, for instance, saying, going up to the person with a shirt and saying, oh, this shirt would go really well with the pants you took. The pants that are in that person's pocketbook or backpack or something like that. Just to let the person know that we know that you've been shoplifting, that type of thing. But a lot of stores say, no, just let them go. And why? Because they prefer to fight shoplifting online. Because after all, most of the merchandise that is shoplifted is subsequently sold either on eBay, maybe Amazon or Craigslist or something like that. And they have investigators looking at those websites to see if the merchandise is there. If their stolen merchandise is there. But anyway, why? Why are if you're working for a store, do they tell you not to confront a potential shoplifter? Well, if you're wrong, you can be sued for false imprisonment. Now, false imprisonment is the intentional confinement or restraint of another person's activities without justification. It can be accomplished through the use of physical barriers or physical restraints or the threats of physical force. Now, moral pressure doesn't count. It's got to be something physical. In addition, it's got to be complete. If there's a way to escape where the person's not going to be injured, then it's not false imprisonment. Now, why do I bring up false imprisonment now? Well, usually, if a store is sued for false imprisonment, they're also sued for what? Assault and battery. Assault when they see the store security guard approaching them and attempting to grab them, and battery after the security guard has grabbed their arm, their wrist, their bag, or whatever the case may be. So assault, battery, and false imprisonment oftentimes go together. Now, there are some defenses to false imprisonment. A lot of states have adopted merchant protection statutes. And what they say is, there are times where a merchant may be justified. They may be mistaken, but they may be justified. And it comes down to three factors. One, did the store have reasonable suspicion? And that's basically more likely than not than someone shoplifted. Two, did they conduct a reasonable investigation? And three, did they only hold the person for a reasonable time? If that's the case, then that's a valid defense, even though they may not have been justified in stopping them, even though they were mistaken. The person didn't shoplift. Maybe perhaps the store clerk forgot to remove the little item that sets off the alarm as you're walking outside through the doorway. That type of thing. So false imprisonment, very important. Another important intentional tort to person is the intentional infliction of emotional distress. So far, as far as torts to persons, we have assault, battery, and false imprisonment. They all go together. And we also have intentional infliction of emotional distress. Now, I don't know if it would really go necessarily with a false imprisonment claim, although it may. It may if it reaches the right level of outrageousness. Now, with intentional infliction to emotional distress, the plaintiff is alleging that the defendant's conduct is so extreme and outrageous to be beyond all bounds of decency. Now, it's got to be more than just hurt feelings. It really has to be extreme. A really good case on it involves Howard Stern. The case of Roach versus Howard Stern, 1988. A case that was heard state court in Manhattan. Basically, in a nutshell, Howard Stern had a guest, had a regular guest, and she had a very sad life. She worked as a stripper and did other things, and she was addicted to drugs. But she would appear on the show from time to time, and Howard Stern would interview her. And she died. She died tragically at a young age. And pursuant to her wishes, she was cremated. Now her sister had her remains, her cremated remains. And it was the deceased wishes that her sister and the deceased best friend, and I put that in air quotes, best friend, split her remains. So her sister did that. The deceased sister did that. She kept half of the remains for herself, and she gave the other half of the remains to the deceased best friend. Now, this so-called best friend went on the Howard Stern show with the remains. Howard Stern asked for the box with the remains in it, the cremated remains, and started to shake the box and tell his sidekick, Robin Quivers, "Oh, I think I hear a tooth. I think I hear a rib bone." Meanwhile, the sister of the deceased was listening to this radio broadcast. Howard Stern then opened up the box and started to shake the remains around. "Oh, Robin, I think I see a tooth. Oh, Robin, I think I see a rib bone." Robin says, "Oh, let me take a look, Howard." And they passed the box around. Well, the deceased sister was obviously what? Devastated, emotionally devastated. She sued Howard Stern in state court in New York. Now, the state court in New York, after discovery, dismissed the plaintiff's complaint. Howard Stern's attorneys made a motion to dismiss, a pretrial motion to dismiss. It was granted. The plaintiff failed to make out a legal claim. The plaintiff appealed. She appealed, went to the appellate division, First Department, right there in Manhattan. And the appellate division, the appeals court, right, she appealed the issue of law, whether or not there was enough evidence to make out an intentional infliction of emotional distress case. She appealed it, and the appellate division, the appeals court, agreed with her. They reversed the decision of the trial court, and they sent it down for trial. They said, no, there's enough discovery here, there's enough evidence here, that the case should go to trial. Let a jury decide. Well, to make a long story short, the case was subsequently settled. So that's intentional infliction of emotional distress. All right. An important tort is defamation. Defamation, invasion of privacy. I want to talk about defamation first. Now, defamation, again, these are still all torts to the individual. But eventually they're going to become torts to businesses. Defamation takes two forms, libel and slander. Libel is written and slander is spoken. Now, defamation is a statement of fact, of incorrect fact, of untrue fact. Now, what if you were to say, for instance, oh no, I have to watch Professor Ertel's lecture again on Blackboard. He's so boring. I wish he would make it more entertaining somehow. Could I sue you? No. Why? Because boring is what? Is that a fact or an opinion? Well, you may feel like it's a fact, but it's really an opinion. It's an opinion. Now, obviously, sometimes it gets close. It's a fact or an opinion, but they're boring. Boring is relative. I think I'm really interesting. So I think it's just an opinion. It's just your opinion, and you're entitled to have it. And no, I can't sue you. However, what if you were to say, oh no, I have Professor Ertel, and I hear that he fails 75% of his students. Is that an opinion or a fact? You're making a statement of fact. First off, it's untrue. I don't fail 75% of my students. It's very hard to fail one of my classes. You really got to try. I don't. That's a statement of fact, and it's an untrue statement of fact, so I could sue you. Now, if you wrote it, say you wrote it on Facebook, I could sue you for libel. It's written. Suppose you told other students at LIM, you told them verbally, I could sue you for slander. So I could sue you for libel and slander. Now, there are a couple of elements. Every defamation lawsuit has got to have, one, an untrue statement. Two, the defendant has to make that untrue statement to a third party. If you're just thinking that I fail 75% of my students, that's not enough. You have to say it, you have to write it so that someone else sees it or hears it. It's got to be, in other words, published. So you have to have, one, an untrue statement, and two, it's got to be published. Third, I have to prove damages. Now here, the difference between libel and slander is important. Which do you think is more damaging, libel or slander? Slander is spoken, libel is written. Well, what's the nature of spoken words? After you tell what the original people, whatever it is you say, once you tell them that untrue statement, the damage is kind of what? It's contained just to those people that you've told, and maybe even over time forgotten. On the other hand, libel is what? That's written. That could be forever. Libel is considered a lot more serious as far as the law is concerned. If it's just slander, the only thing the plaintiff can collect for is special damages. In other words, if I lost my job, lost wages. If it's libel, not only can I collect special damages, I can also collect general damages, loss of reputation. So let's work it out. If it's slander, spoken words, and you say that I fail 75% of my students, well, certainly those students that you told, they would probably be a lot less likely to take my class. Right? All of a sudden, no students want to take my class. That doesn't look good for me. And it's LIM. The college is not going to really like it either. So maybe they let me go. Sorry, Professor Ertel, no one wants to take your class. We heard that you failed too many students. Well, I've lost have lost wages. Now, what if you were to write that? What if you were to write that on your Facebook page or the college newspaper or something like that? Well, one, it's not just limited to who you've told, but now anyone who reads it, will have that opinion of me. that I fail 75% of my students. And two, when you write it, it's permanent. I mean, you can, go back to a Facebook posting unless you delete it. You can go back. Their postings are years old. Or in a student newspaper, those are around forever. You can look it up online, so it's there forever. In that situation, I can not only collect for special damages, but also for general damages, loss of reputation. Before, students had a fair view of me, that I gave all my students a fair shake to do well and to pass and to thrive. Now they just think I failed them. Loss of reputation. All right. Now, there are some examples, some exceptions to that, where a person can collect general damages, whether it's libel or slander. And that's called defamation per se. And that is when you make a false statement about someone's either sexual conduct, criminality, they're suffering from some kind of disease, or they're unfit to practice in their trade and profession. So, for instance, as an attorney, what if you were to say something like, "Oh, don't use Professor Ertel. I heard that he is a dishonest attorney who steals from his clients." Well, you've made a pretty strong statement about my fitness to practice in my trade or profession. So whether you only spoke or wrote those words down, not only can I sue you for special damages, I can also sue you for general damages. Now, what if it's true? What if it's true? What if the allegations you're making are true? Well, truth is a defense to defamation, whether it is libel or slander. So keep that in mind. Truth is a defense. All right. There is an important distinction, though, in defamation about public versus private figures. Now, why? Well, suppose, for instance, everyone knows who Senator Schumer is. He's the senator from New York. He represents New York State in the U.S. Senate. What if I were to say something along the lines of, I think Senator Schumer is misguided. His policies have cost, and his political stances have cost New York over 2 million jobs. Well, that's clearly a statement of fact. And assuming I can't prove it, could he sue me? Well, he could. But he's also a public figure. He's a senator from New York. And as such, he's in the political arena. Now, political speech is what? 100% protected. So my speech against Schumer, because he's a political figure, is, to a very large extent, political speech. It's given additional protection. He is definitely a public figure. Now, what does that mean? Well, that means that he also has to prove not only that I made an untrue statement, but that I made it with reckless disregard for the truth. That is, I knew the statement was untrue, or I knew of facts that should cause me to question the veracity of the story. Very important. Very important indeed. He's got to prove those two additions. Not only was it untrue, but I did it with reckless disregard. One, I knew it was untrue, or two, I knew of facts that should cause me to question the truthfulness of the story. Why do we put these additional burdens on public figures? Because public figures are oftentimes political, and political speech is fully protected. Now, oftentimes there's an issue about whether someone is a public figure or not. What about Mayor Bloomberg in New York City? Is he a public figure? Yeah, I think so. I think almost everyone knows who he is, certainly in New York, and he's taken stands on national issues. So he's probably a public figure. That's the mayor of New York City. What about the mayor of Mineola, Long Island? He's a mayor too, or she's a mayor. I don't even know who the mayor is. Are they a public figure? The mayor, is he or she a public figure? I don't know. That's a question of fact. Maybe in Mineola, the mayor is a public figure, but the jury is just not going to be pulled from Mineola. They're going to be pulled from all over Nassau County. So maybe not. I don't know. That's a question of fact, whether or not someone is a public figure or not. What about the mayor of, say, Cleveland, Ohio? Well, I would think Cleveland's, I think, the biggest city in Ohio, and maybe the mayor of Cleveland, Ohio is a public figure, at least in Ohio. But you can see where, the whole distinction of public versus private figures, you can get a little bit dicey. You have one extreme like Mayor Bloomberg, then you have another extreme like the mayor of Mineola, New York. So, that is an issue of fact. All right. Another important tort to individuals is invasion of privacy. Now, the law recognizes your right to be left alone and has for a very long time. If you don't want attention, you don't have to have attention. Now, the key issue here is, does the plaintiff have a reasonable expectation of privacy? So, for instance, suppose it's a beautiful day and you are walking through Central Park and you can't believe your eyes. You see Brad Pitt and Angelina Jolie. Now, they've taken steps to conceal their identity. They have hats on and sunglasses. But you are a huge fan of Brad Pitt, and you certainly know what Angelina Jolie looks like. You take their picture. Have you invaded their privacy? Well, do they have a reasonable expectation of privacy? Where were they? Central Park. One of the busiest parks in all of New York City. Not really. I would say no, they don't have a reasonable expectation of privacy, even though they did, in fact, take precautions to protect their privacy. Now, what constitutes invasion of privacy? Well, there are 4 ways privacy can be invaded. One, using somebody's identity, using their name, their picture, their likeness for commercial purposes. This is also known as the misappropriation of publicity, which we'll talk about either at the end of this lecture or the next lecture. So using someone's identity, their likeness, their name, their picture for a commercial purpose. Why is that invasion of privacy? Because you have a right to be left alone. You want to be left alone. All of a sudden, what? Your picture is in a commercial, it's on some billboard. People will do what? They will come up to you and do what? You're the person on that billboard, aren't you? So your privacy has been violated. Another is intrusion into the person's private affairs or seclusion. So, for instance, looking in someone's bedroom window or living room window, opening up their mail, going into their email account, listening to their telephone conversations, really taking steps into kind of these zones of privacy. That's another way there can be invasion of privacy. The public disclosure of a private fact. For instance, people's social security numbers. Most people, rightly so, keep those very private, and you should. What if you disclose it? Absolutely. What if you're sick and you don't want anyone to know, and it's been disclosed? That's also invasion of privacy. Absolutely. So it's kind of related to intrusion of someone's affairs or seclusion. So if you go into someone's email account and they have, personal data in it, and then you committed invasion of privacy by doing that, by invading their affairs or their seclusion. And 2, you've committed invasion of privacy when you made that private fact public. And 4, the 4th way you can commit invasion of privacy is casting someone in a false light. Now, this is a real case. It involved a 98-year-old woman in Arkansas. And there was one of those tabloid magazines that you see at the supermarket checkout counter. And that tabloid magazine had a picture of this 98-year-old woman, very real, very much alive. And underneath was the caption, "World's oldest mother gives birth." They were alleging what? That this 98-year-old woman gave birth. She sued for invasion of privacy. Well, why? Why? Well, now all of a sudden, it's kind of like when you use somebody's likeness for commercial purposes. Now all of a sudden, what? Every time she sees someone, they may say, "Hey, that's the world's oldest mother." She didn't want that attention. She did not want that attention to be brought upon her. In other words, her invasion, her privacy has been invaded. All right. These are all important torts. Now, the next tort I want to go over is the misappropriation of the right to publicity, also known as the tort of appropriation. It is kind of related to invasion of privacy. As a matter of fact, it kind of grew out of invasion of privacy, and it grew out of the sports industry when it developed over 100 years ago, the movie industry, and yes, even the fashion industry. Absolutely. The misappropriation of the right to publicity, also known as the tort of appropriation. This tort to persons holds that things like branding, image, likeness, name, personality, these are valuable assets that everyone has. Each person has the exclusive right to use these things and to profit from them for their own benefit. Someone just cannot use your face, your name, or your likeness to sell something. Now, this grew out of the sports industry. How? Specifically baseball. So baseball started to become really popular about 100 years ago. As baseball players were traveling across the country, they saw their names on billboards endorsing cigarettes, beer, and other consumer goods. Yet they never gave their permission to do so. Same thing with respect to movie stars. The movie industry, motion picture industry really started to become popular a little bit less than 100 years ago with silent film. All of a sudden, all these silent film movie stars started to see their likenesses, their pictures, endorsing various products. Excuse me. Well, these athletes and movie stars and other celebrities felt violated. They started to sue. And the courts recognized this tort of the misappropriation of the right to publicity. Now, name is really simple. Right? You just can't use someone's name to sell something. Image is really simple. You just can't use someone's picture, whether it's a photograph or a drawing of them, to sell something. Again, not without their permission. But what's likeness? Likeness is a little bit more amorphous. Likeness is really someone's personality. And how far does that go? For instance, The Gap. They had an advertising campaign a couple of years ago, wherein what? They used a model that looked like whom? A lot like Kim Kardashian. Wasn't Kim Kardashian. It was a model that looked like her. Well, she threatened The Gap and Old Navy, etc., to sue. And one of the causes of action that she would allege is the tort of appropriation, that you're using her likeness. How and why could she sue? Well, that was part of her image. I'm sorry, that was part of her likeness. Now, is that fair? What about to the model? Is it her fault that she happens to look like Kim Kardashian? What are you telling this model? Sorry, you can never work as a model again because you look like Kim Kardashian. Don't you have a right to work? Doesn't that model have a right to work? Well, maybe not. Maybe not if you're going to be sued by Kim Kardashian. So likeness. It's more than just image. It's more than your name. It's your personality. It's your personality. There have been some interesting cases throughout this tort, and as you'll notice, they all involve celebrities. Why? Two reasons. One, celebrities usually have the assets to pursue these types of lawsuits. And for celebrities, of course, their name, image, and likeness are valuable assets. And two, California law is pretty strong on this for the plaintiff. Why? Well, the entertainment industry is such an important part of their economy. They're protected. They're protected. All right. So we mentioned Kim Kardashian and the lookalike model. Well, yeah, lookalikes are definitely the tort of appropriation. One case is Woody Allen versus National Video. Woody Allen asked for an injunction preventing the use of a lookalike in a commercial, and the court granted it. What about nicknames? Could they be part of your image or likeness? Yeah, absolutely. Muhammad Ali, his nickname was the greatest, at least when he boxed. He went by that nickname. Well, Playgirl magazine once published a drawing of a nude African-American male, and over the drawing was the caption, "The greatest." He sued and he prevailed. Now, what about a phrase? Right? Paris Hilton likes to say, "It's hot," or "That's hot," or whatever. I don't know. Could that be part of your image? Absolutely. The great talk show host Johnny Carson, a phrase that was associated with his show and thus part of his personality was "Here's Johnny." Johnny Carson may have been a comedian, but he didn't laugh very much when "Here's Johnny Portable Toilets" used that phrase for their company name. He sued and he prevailed. So yes, that's my daughter's cat again. I'm sorry. She's on the hunt for something, I don't know what. What about singing style? Could that be part of your likeness? Well, yeah, absolutely. So think about a singer today with a distinctive style. Maybe Adele. She has a distinctive style. But Adele is not completely original. Dusty Springfield, a singer from the '60s, sang a lot like her. And she's still very much alive, and I think she still sings. Could she potentially sue Adele for using her singing style to sound alike? Well, again, it's kind of like the same issue with the model. I mean, just because Adele happens to sound a little bit like, maybe a lot like Dusty Springfield, does that mean she can't make a living as a singer? Well, Bette Midler, the pop singer, she had a very distinctive style of singing. She had a very nasally quality to her voice. And she sued Ford Motor Company and prevailed when Ford used a singer's voice that sounded a lot like hers. So maybe Dusty Springfield could sue Adele. What about a former name? A name that you've given up. You don't even want to use it anymore. Well, yeah, that's still part of your likeness. Kareem Abdul-Jabbar was a famous basketball player. He retired about 24 years ago. Now, Kareem Abdul-Jabbar, that was the name he took when he converted to Islam when he was still a young man. In college, he played basketball under the name Lou Alcindor. And he sued. He sued when a television commercial used his former name. GM, the car company, used Lou Alcindor in a television commercial for one of their cars. He sued and he prevailed. So this idea of likeness is pretty broad. It's pretty broad. Now again, a lot of that is because under California law, celebrities are given a lot of protection for their name, image, and likeness. But still, it's something you got to keep in mind. All right. I'm going to cover one more tort. I see I'm approaching 50 minutes here. And then we're going to cover business torts and negligence in the next lecture. Fraudulent misrepresentation. This involves contracts. And basically, what is fraudulent misrepresentation? It's a representation, a misrepresentation that leads one to believe in a condition that is different from the condition that actually exists. Basically a lie. Basically a lie. And based upon that lie, a party, the plaintiff, has taken certain actions. So, what does a plaintiff have to prove for fraudulent misrepresentation? Usually, it's connected to some kind of contract. One, the defendant made a false misrepresentation of a material fact. Fact has got to be central. The fact has got to be the inducement to the action. It's got to be the inducement for the plaintiff to sign the contract. Two, the defendant had knowledge that the representation was false and intended to deceive the plaintiff. Three, the plaintiff justifiably relied on the misrepresentation. And four, the plaintiff was injured as a result. Now, it's more than just sales puffery. It's more than just this is the best car on the market. What does that mean, the best car? Best by what standard? Price, size, value, speed, fuel efficiency? What does that mean? That's just sales puffery. But what if the person selling you the car said, this car will get 40 miles to the gallon. It has new brakes and new tires. Well, now they're what? They're making statements of fact, not just telling you it's the best car. They're making statements of fact. And those are pretty, those are pretty material facts. Those are maybe your inducements to buying it. So that would be the tort of fraudulent misrepresentation. All right, that's enough for this lecture. Next lecture, we're going to do business torts. We're going to finish up intentional torts, which includes business torts and also briefly torts to property. We're also going to briefly cover cyber torts, and we're going to do negligence. All right, thank you, and please email me any questions.